Welcome back, ladies and gentlemen. So, we had another court case in the Chad Daybell matter in Idaho. Daybell, Don Bell, being the co-defendant of Lori Vallow in the conspiracy to commit, a series of different crimes to hinder prosecution, destroy evidence, in the death of Ty Lee and JJ Vallow and Ryan, respectively. And today's case, what was supposed to be a live court appearance by the attorneys, the court reporter, and the judge, turned out that they handled everything off the record behind closed doors and only did an actual video conference that was live for 3 minutes, and I will play that here shortly, of the actual, like, hey, we all agree with this? Yep, okay, great. Well, see you later. That's it. Everything else was held behind closed doors. Extremely frustrating for anybody out there who is actually following this case, and particularly those who, like myself, who are reporting on this case when things like this happen. Because in order to get the actual documentation to prove what took place during this behind closed doors meeting, I'm going to have to wait until after now the case has been concluded and then submit a formal request, pay up money, because they don't give away this stuff for free in actual court documents. I will have to pay for it, and anybody else will have to pay for it, because it will not be released online. They will hold it behind, closed doors, because they know, especially after the Christopher Watts case, and they learned just how many internet sleuths are out there. They've learned that it's a moneymaker, especially when it comes to getting documentation within the case. So many people are going to want it, and they're willing to pay up. So it might cost $25 to get a copy of the actual transcript of today's meeting. But in hindsight, what did we really learn from the actual meeting itself? Nothing. What did we learn from the DA in the past week, if anything at all? Well, we learned that they are now testing blood evidence that was found in one of the apartments. Of course, they're not going to tell us which apartment, because that would ruin the surprise. That it was either in Lori Vallow's apartment or it was in Alex Cox's apartment. Blood evidence that was obtained from inside of the actual apartment is all it says in the release, along with DNA evidence that was found on tools that were in the storage outbuilding on Chad's property that is going to be tested for blood and for DNA. Mr. Pryor apparently filed some objections to this, that they were going, some of the samples are not large enough to, split the sample. The state tests one part of the sample and they can send it to their own independent laboratory for testing. But that's it. That's what we learned. It kind of defeats and goes against the actual protocol. And in case you're not familiar with the actual protocol, and I double checked this with my wife, who has 25 years experience working in a forensic laboratory, and she also worked in a hospital setting in the custody and chain of command for DNA samples for different types of cases, be it rape cases, murder cases. She dealt with it all in her 25 years of experience working in forensic laboratory and in medical laboratories. This is how the chain of command and all of it works. First, when an item is tested for DNA or someone is tested for DNA, that person must be certified. The person who takes that must use let's just say that they're going to test an actual person. They use an actual swab, not like a cotton swab, like a Q-tip that you'd buy at the grocery store. It's usually a swab on a stick, wooden stick. And they also have ones that have plastic, that are made out of plastic as well. But mainly wooden ones are used for medical purposes. So they use that swab, and then it goes into an actual container. They seal it. They sign that sample that they are the ones who took that sample. That sample is then sent via courier. They don't put it in the United States Post Office in a paper envelope and mail it off. They don't send it off UPS. It goes by a certified carrier because there has to be a chain of command in custody for that actual item. The courier signs for it when they pick it up. They then bring it to somebody else. Somebody else there signs for it. They log it in as evidence. It goes into a controlled environment, usually a refrigerator or freezer, depending on what type of sample it is. It's signed in there. Then, as they work through their case log, there might be other cases ahead of them. There might be a lot of cases ahead of them of that actual testing. But it's preserved so it will not degrade in value. They then take that sample out, they replicate it in the laboratory, basically taking a sample and I think it's called PCR, I think is what she said, but I could be wrong there. They replicate it and then they test it, and then the lab never knows who that sample is of or what that sample is of, unless it's a tissue sample or something like that, and then they may know, well, so that's obviously somebody's eyeball, or that is someone's foot. They may know that it belongs to somebody, but they won't know the actual individual, or anything else. It just has a case number assigned to it, and that's it. It keeps them completely out of it, and being able to be swayed in one direction or another. What Mr. Pryor wanted to do was circumvent that entire thing and cut it off before it ever went to the state crime lab, and said, we want half the samples, and so we can send it to an independent company who is certified through a state agency or a federal agency to test samples, but they may not be held to the same stringent standards as a state forensics laboratory. What normally happens is what I just explained. The state sends that sample off, they get it tested, and once they get the results, they're sent back to the actual prosecuting attorney. He then shares that with the defense team of what the actual results are. And that's how that normally happens. But Mr. Pryor wants to circumvent it all and say, look, everything that you have that has DNA evidence on it, we want it split in half. Give us half, you take half. What if in the case where there may only be one single droplet of blood on a tool or in the apartment? There's obviously not enough evidence there to be split in half to have a full sample to be sent off to two different labs. He doesn't care. So I guess you just can't test it then, is basically what the defense is hoping for. That's all we've learned. That's it. Because again, everything was held behind closed doors. So there's nothing more for me to add to this case except for that it doesn't look like the state of Idaho is in any hurry at all to go to trial on the misdemeanor part of charges that are just against Lori. We keep on talking about evidence and testing and motions and everything else. No date on when that everybody has to stop filing motions, and it's just going to go on and on and on.
All right, good afternoon, everyone. We'll go on the record now. Let's make sure we have our court reporter. Mr. Fuller, are you there? Very well, thank you. This is Fremont County KCR 222755, State of Idaho versus Chad Daybell. Mr. Daybell is represented by his attorney, John Pryor. And if you give me just a second, I'm going to mute because I got a siren going by here. All right. This is the time we have scheduled for a hearing on the defendant's motions, motion to oppose use of and motion to preserve DNA samples, motion for photographic recording of serology samples and other visual tests, and motion to review lab records. Before we started this hearing, I discussed the matter off the record with counsel, Mr. Pryor and Mr. Wood. The state did file a response to the motion indicating that it didn't entirely object to some of the issues in the motion. Council has agreed to try to see if this issue can be resolved through stipulation, and there are some additional issues that we're going to need to find out from the state lab in order to potentially reach a stipulation. And so in order to allow time for that, it's my understanding the parties have agreed that we should continue today's hearing with the proviso that the state would agree to refrain at this time from any consumptive testing of any evidence in its custody at this time. In other words, any testing that would completely consume the evidence, leaving it unavailable for examination by the defense. And then we could bring the case up again or potentially not have to hear the motion on the basis of a stipulation. So that's what I understand we intend to do today. Mr. Pryor, does that recitation I just gave comport with your understanding of where we are today?
It does, Your Honor. Thank you.
All right, thank you, Mr. Wood and Ms. Smith. On behalf of the state, are we okay to continue this matter?
Yes, Your Honor.
All right, very well. And again, Mr. Wood, as I mentioned, obviously part of that agreement is that the state would refrain from any consumptive testing until this issue is sorted out. Council, if you need to have a hearing on this, just contact the court and we can do that potentially even on an expedited basis if necessary. I think that's all we've got for today. Then is there any other issue we need to bring up, Mr. Wood or Ms. Smith from the state?
No, Your Honor.
All right, Mr. Pryor, Mr. Means, anything further today?
No, Your Honor. No, Your Honor. Thank you. May I be excused?
You may. Thanks, council. We'll go ahead and log. Thanks everyone for setting up the hearing today.
Are we ever going to get justice for Ty Lee and JJ? When are we going to get justice for Tammy, for Charles, and for Joseph? Right now, it doesn't feel like it's going to be anytime soon. Thank you for joining me today.